Moore. Mr. Moore, could you unmute and state your name for the record, please?
Oh, there he is.
DeQuante Moore.
Right out of the gate, this hearing already has the feeling of a procedural mess waiting to explode. The defense is asking for more time to negotiate with prosecutors, but the real tension here is bond conditions, and Judge Simpson immediately locks onto it. That matters because bond arguments are never just about paperwork. They're about risk, trust, and whether the court believes a defendant will follow the rules outside jail walls. And listen carefully to the energy in this courtroom already. Nobody sounds fully confident. The defense is trying to clarify tether conditions, prosecutors are preparing resistance, and the judge is clearly remembering prior hearings. That's dangerous territory for the defense because once a judge starts saying things like, "I remember hearing this the last time," it usually means patience is running thin. What makes this especially interesting is how something that sounds technical, a GPS tether versus home confinement, can completely change someone's freedom. One, restriction tracks movement. The other basically locks you inside your house. Huge difference. And the court is about to dissect that difference, line by line. Question for you watching. If someone already has a GPS tether, should that be enough supervision? Or should courts demand stricter confinement for repeat offenders?
Thank you. All right, what are we doing?
Your Honor, we are asking for an adjournment in this matter. We're still working on an agreement with the prosecutor. We'd also like to address bond.
He's out. All right. Probable cause conference, November 2nd, 2023, 9 a.m. Oh boy, this could go south. Go ahead. What about bond?
Your Honor, Mr. Moore is currently on a home confinement tether. I was not the attorney who worked on this matter previously, but my understanding is that one of the reasons for the home confinement is because the court was under the impression that his tether from, I think it's Macomb County, was also a home confinement tether. We have since received the information confirming that it's a GPS tether. We're asking that the court first. We're asking.
Hold on, but it's a GPS. I mean, a GPS can be a home confinement.
Yes, I think it's only for purposes of keeping track of his whereabouts. It's not just simply.
So it's a location tracking.
Thank you, Judge. I'm gonna write that down so I can say that next time. It's a location tracking tether. So we're actually asking, and I know that we've spoken with the prosecutor about this. They're going to object to that particular request. He still has the GPS tether, the location tracking tether from Macomb on, and he also has the one from Washtenaw County on.
So let me just tell you, I remember hearing this the last time.
Okay.
And what's very clear from the order was that the magistrate ordered a home confinement to an address and then said currently has a tether from Macomb County and is confined to home.
This is where courtroom hearings become less about emotion and more about exact wording. Judge Simpson is zeroed in on the magistrate's original order, and you can hear the problem developing in real time. The defense is trying to reframe the tether as simple location tracking, but the judge is focused on what the paperwork actually implied: home confinement. And honestly, this exchange is a reminder that tiny legal distinctions can completely control somebody's life. The defense keeps trying to soften the terminology, GPS tether, location tracking tether, but the court is basically saying, call it whatever you want, I'm looking at the restriction itself. That's a massive uphill battle. Then suddenly, the hearing takes a sharp turn into comedy and irritation at the same time when another public defender jumps in uninvited and Judge Simpson instantly shuts him down. Get out of here. We don't need your help. Brutal. The judge isn't interested in side commentary, interruptions, or extra voices muddying the record. And notice something important. Courtroom credibility matters. If the judge feels attorneys aren't fully prepared or communicating clearly, That frustration can spill over into rulings. You can practically feel the patience level dropping second by second here.
I understand that, Your Honor. And I think that we have received confirmation on what the details of that tether was. Mr. Moore, am I correct? Is it a home confinement tether from Macomb?
The Macomb County is just a GPS tracking tether to make sure that I don't leave the state.
If I can be of assistance, Judge, Torshell Feaster, Assistant Public Defender.
Get out of here. We don't need your help. Get out of here, sir.
I did have the case last time, Judge.
So,
I'm always willing
get
to
out,
help.
and he's still talking. Apparently doesn't listen either. Go ahead.
I'm a bad listener sometimes. I just want to confirm that I did receive an email from his agent, from his Tether agent in Macomb County, and I believe we forwarded that to the prosecutor's office as well. So we do have confirmation that it's just a location tracking tether that he has there, Judge. Just want to be helpful. So, sorry, I'll go away.
No, I'm just trying to figure out how your office mate didn't tell me all that.
Well, she's new to the file, Judge. She's got a new assignment.
Oh, okay. No, I don't know. Miss Hughes, your response.
Thank you. Thank you for also clarifying what the notes in the file were. I am not in agreement to him being on only a GPS tether for a couple of reasons. One is, first I'll say, I was not present at this arraignment, so I don't know for certain. I understand what Your Honor read into the record from the magistrate's notes. I don't know for certain that the only reason that Magistrate Fink, or whoever the magistrate was, issued a home confinement tether was because he or she believed that he was already home confined from Macomb County. Instead, at the time of arraignment, my office requested a $20,000 cash surety on this case.
Now, the prosecution starts laying out why they believe strict supervision is absolutely necessary, and this is where the tone of the hearing shifts from technical tether arguments to public safety concerns. Prosecutors are no longer debating terminology. They're building a narrative about escalation, repeat behavior, and risk to the community. The state immediately emphasizes that this is a home invasion case happening close to where the defendant currently lives. That proximity matters because prosecutors often argue it increases the likelihood of repeat conduct or witness concerns. Then comes the criminal history rundown, and you can hear the strategy clearly. Prior parole, prior probation, vehicle offenses, assault-related convictions, juvenile history. They are stacking history on top of history to show the court a pattern instead of an isolated mistake. And from a courtroom strategy standpoint, this is powerful because bond hearings are often about predicting future behavior. Prosecutors don't need to prove guilt beyond a reasonable doubt here. They just need to convince the judge that tighter restrictions are justified. You can already sense where this is heading. The defense is arguing for reduced confinement while the prosecution is essentially telling the court every prior opportunity for supervision has failed. That is a very hard argument for any judge to ignore.
I am continuing to request the home confinement tether, or frankly, he can wait in jail if he doesn't want to be on a home confinement tether. This defendant, so this is a home invasion case. The defendant and his co-defendant or co-suspect are on surveillance video. They entered a home that is actually not too far from the address that he is currently home confined to. It's about a 6-minute drive. He entered the garage of that home, and the garage door had been inadvertently left open overnight, and the defendant and his friend went in and stole things from the garage. He does have quite a criminal history, though, in the sense that he was on parole and discharged from parole on November 30th, 2022 for receiving concealing a motor vehicle. This was even after he was already on felony probation for unlawful driving away of a motor vehicle, as well as multiple assaulting the police R&O convictions. He has an extensive juvenile history that includes home invasion, UDA, CSC, indecent exposure, aggravated assault, another UDA, another receiving and concealing motor vehicle, more R&Os against the police. So my understanding, and this is just limited to my review of the file, I was not present at the arraignment. My understanding was that, I should say it like this. My belief was that a home confinement tether was ordered because that is appropriate supervision for this defendant who has continued to commit these crimes despite already going to prison, despite already being on felony probation, and despite already being on parole. This is an appropriate supervision for him at this time, even if Macomb County decides to only give against Tether. Thank you.
All right. I would agree with that. I looking at defendant's previous history and the proximity of these offenses to parole and his release from parole, the court is going to decline to change the GPS tether. That will remain in place. Bond will continue. Thank you.
Thank you.
Thank you, Your Honor.
Judge Simpson's ruling here is short, but it carries a very clear message. The court is prioritizing supervision and caution over flexibility. Once the judge started talking about criminal history, parole timing, and proximity to the alleged offense, the defense was already fighting uphill. By the end, the decision almost felt inevitable. What stands out is how quickly the judge aligns with the prosecution's reasoning. There's no long hesitation, no extended balancing test out loud. The court basically says the existing restrictions stay in place, period. And that tells you the judge believes the current conditions are appropriate given the defendant's record and circumstances. But courtroom calendars move fast, and immediately after one tense ruling, another defendant steps forward. This next case changes the tone completely. Instead of tether disputes and home confinement, now we're moving into allegations involving domestic violence and repeated assaults inside a long-term relationship. Different facts, same high stakes. And this is one of the reasons courtroom breakdowns are so fascinating. Every few minutes, the emotional landscape changes entirely. One defendant is arguing over supervision conditions. The next is fighting over accusations involving strangulation, physical violence, and prior domestic violence convictions. The pressure never stops inside these hearings.
Cameron Curtis.
We are pleasingly ready in this matter, Your Honor.
Alexander, on behalf of the people.
Anna Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Cameron Curtis. Mr. Curtis, please state your name for the record.
Cameron Gage Curtis.
Your Honor, today is the date and time set for probable cause conference. We are respectfully requesting to have this matter set for preliminary examination, and we would like to address bond briefly.
All right, all discovery is complete.
As far as we know, yes, we have all the discovery.
Preliminary examination will be set October 24th, 2023, 9 a.m. Before Judge Washington. As to bond.
Your Honor, my client is respectfully requesting that his bond be reduced to $5,010%. He does have a job in Belleville, Michigan at the Red Oak. He is employed as maintenance. He lives in Belleville. He will follow all strictures and requirements of the court. He will appear to all future court dates. He has no place to which he would flee.
Response.
Your Honor, at this time, we believe the bond is appropriate and ask that it be kept the same. In this, the victim and him had been dating on and off for 7 years. She stated that he assaulted her multiple times over the previous 3 days, and the first assault occurred when he got angry at her and she was trying to calm him down. He then strangled her by grabbing the front of her throat with his hands. She tried to get away from him. He then grabbed her hair and attempted to force her into a room. She was then able to get away and fell into the concrete as she was trying to escape. She then got into her mother's car, who just arrived, and he came up to her in the car and slapped her in the face. Officers saw injuries to her neck, face, and arms when they arrived.
This is the exact moment prosecutors start painting a picture that can heavily influence bond decisions. Notice how detailed the allegations become. Repeated assaults over several days, strangulation claims, attempts to prevent escape, injuries observed by officers. Prosecutors are trying to establish not only seriousness, but also danger and escalation. And in bond hearings, strangulation allegations are especially significant because courts often view them as high-risk indicators in domestic violence cases. That's why the prosecution is emphasizing physical injuries and prior convictions almost immediately afterward. They want the court to see a pattern rather than a one-time accusation. The defense responds predictably by saying the client denies the allegations and expects vindication later at preliminary examination. That's standard strategy because this stage is not a trial. Nobody is determining final guilt here. The court is deciding what level of restriction is appropriate while the case moves forward. Still, from a viewer perspective, you can feel how emotionally heavy this hearing becomes. Allegations involving violence inside relationships always carry extra intensity because courts know the risks can continue after release. Question for viewers: when judges make bond decisions in cases involving alleged domestic violence, should prior convictions weigh heavily even before the current case is proven in court?
He also has a 2021 DV conviction, another 2021 DV conviction, and then a 2021 malicious destruction of a building misdemeanor conviction. So we believe bond is appropriate at this time.
Your Honor, my client, of course, denies the allegations in this matter. He feels that he will be vindicated at preliminary examination.
Motion for bond reduction is denied. Bond will continue.
Thank you.
Thank you.
Your Honor.
Pardon?
2 weeks, please, Judge.
All right, here's going to be the problem with this, and there's going to be another case along these lines. This bond was improperly set.
Oh, okay.
The arrearage on this matter was, at the time, was $333, and his bond in this case should have been set. I mean, even if I just take it from the 18, his bond should have been about $4,500 plus, but and he was released on a PR, which is absolutely inappropriate in violation of statute. So we're going to have. Well, I don't know what you wanted to say, Mr. Goebel.
The Ms. Fink, the judge, said that unless there's probable cause of why I didn't pay, then that's the only reason she can give me the PR.
Excuse me?
She gave me the PR bond because she said that it says under the statute that if there's probable cause of why I didn't pay, if she feels like there's probable cause, then she can give me a PR. And that's what she did.
This hearing suddenly transforms into something much bigger than a normal bond discussion. Judge Simpson is now openly saying the previous bond decision may have violated statute, and that is a serious moment in any courtroom. You can hear the defendant trying to explain why he believed the personal recognizance bond was lawful, but the judge immediately shifts the focus back to statutory requirements. And honestly, this is one of the most uncomfortable situations defendants can face. Being released under one ruling only to later hear another judge say the release itself may have been legally improper. That creates a nightmare scenario because the defendant may feel like he followed the court's instructions, yet now faces the consequences of a judicial correction. What also stands out is Judge Simpson's tone. He's not yelling or being theatrical. He's methodically walking through the numbers and legal obligations. But sometimes calm rulings hit harder than emotional ones because they sound unavoidable. Once the judge starts calculating exact percentages and cash requirements on the record, you can almost feel the outcome locking into place. This is no longer about negotiation, it's about statutory compliance. And that usually leaves very little room for flexibility.
I don't think that's the reading of the statute, but there would have to be a finding of that, and I'm not sure that the Attorney General was there to give probable cause.
Okay.
Your bond was set in that amount. The court does find that that's an abuse of discretion in setting the bond in that amount.
How much is the 25% judge that he was supposed to have paid?
The 20, based upon what's on the complaint, and it may have gone up now. To get the exact figure, I can give it to you just a second. I think it's 18. It'd be $4,583.
Okay.
So what I'm going to do, sir, and I apologize to you, but that the statute is what the statute is. And it requires that it be set at 500 or 25% of the arrearage, whichever is greater. And obviously the arrearage is greater. So your bond will be set in the amount of the $4,583. There's 25 cents, but I'm not going to worry about that. I'm just because $4,583 that has to be paid in cash, and that needs to be then applied to case number 2006 000159 DP.
Your Honor, I do not have that money to pay that.
I understand, sir. I may understand that, and that might have to be dealt with otherwise. But you know, like I said, I don't write the statutes. I just have to enforce the statutes that's written, unless some other agreement can come up before council that they think the court would approve. But at this juncture, I'm going to set your bond at that amount. Regrettably, sir, I'm going to have to order that you turn yourself into the Washtenaw County Jail, and that you're to report to the jail by 6 p.m. this evening, or a bench warrant will issue with the bond set in that amount.
Mr. Goebel, I just put my phone number for the office into the chat. Please give us a call so we have your updated information and we can talk about the bond and potential ways to remedy the situation for you.
All right.
Okay, so call us immediately, please.
All right, I need
I will, despite of that regarding the bond, I will adjourn the probable cause hearing. I'll adjourn it to June 8th. My apologies, but I have to do my job.
And here comes the emotional collision between law and reality. The defendant openly tells the court he does not have the money, and for a moment you can hear how difficult this situation becomes for everyone involved. Judge Simpson actually sounds sympathetic, but he also makes something crystal clear. Judges enforce statutes, they do not rewrite them. That's one of the harsh truths of courtroom procedure. Sometimes a judge can recognize the hardship while still enforcing the rule exactly as written. The court recalculates the bond, orders the defendant to surrender himself to jail by 6 p.m., and warns that a bench warrant will issue otherwise. That is a life-changing moment delivered in just a few sentences. At the same time, defense counsel immediately shifts into damage control mode, telling the defendant to contact the office and explore possible remedies. That's important because even after difficult rulings, attorneys often continue negotiating behind the scenes looking for alternatives, agreements, or modifications. Overall, this hearing was packed with tense bond disputes, supervision arguments, domestic violence allegations, statutory corrections, and multiple moments where Judge Simpson firmly reasserted courtroom authority. Whether it was tether restrictions, prior criminal history, or mandatory financial obligations, the court repeatedly emphasized accountability and compliance over convenience. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.